And here we are. Hi, I'm Neil, your DevOps expert, and also a bit of an expert in the consulting area as well. I've been a DevOps consultant now for a long time through my own limited company, and I've used umbrellas before. But enough about me, let's get on to what we're talking about today. We are talking about Contractor's Guide to Legal and Compliance Considerations. And this is a somewhat scary area. I know that sometimes it's quite easy to get on and do some stuff and stay within the colouring lines, but sometimes you have to make sure you don't cross the lines. Anyway, so let's get into this. First of all, the easiest thing to do to stay within those lines is to have the contracts well drafted. You should have a scope of work, the payment terms, how quickly you're going to get paid or how often, the confidentiality agreements, what is confidential and what isn't, and how long it stays confidential for, termination clauses, how you can quit out of the contract, and how your customer can cease the contract if they need to. And dispute resolution, if I've got my teeth in, which is some sort of guidance about, hey, if something goes wrong, can we do something about it? Is there a third party that we can contact to sort of mitigate the dispute? So, other things that are in compliance that you need to know about is intellectual property rights. Now, this can also be in the contract. So, what is IP? It is stuff that you've created. It can be as vague as that. So, in my line of work as a DevOps expert, I quite often write code, be it in Python or Bash script or whatever. But I'm creating it, and therefore that's intellectual property that I've created. But if I've created it for a client, who owns it? Well, in my contract, it says whilst I'm billing the client and I create stuff for the client, it belongs to the client. Sounds quite straightforward, doesn't it? And then if I'm doing stuff on my own time, in the evenings, a side project or whatever, that's my IP and I own it. I'm not billing the client for that time, therefore it's mine. But at that point, it can get a little bit hazy. So it's in the contract. As long as the client gets what they want, usually everything's happy. So it can include anything that you might want to copyright or trademark or something like that. One of my friends designs logos. Now, obviously, he doesn't design his own logo all the time. He's designing client logos, but it's the same deal there. He's creating an image for the client to use. It belongs to the client after they've paid the invoice. Easy peasy. But further about the ownership, it can be licensed. It doesn't have to be a one-way street. It could be that I've written this code and you're allowed to use it for subscription, or as long as you employ me on this contract. As soon as the contract ends, you cease to have any rights over that code as the client, and it reverts back to me. The other side of it is pre-existing IP. What if I've written a library that helps me create some solutions, and that was before I even met or started working with the client? That's pre-existing IP. And so that can be included on a license, as I just mentioned, or maybe it's open source, so it has an open source license, which means anybody can use it, or something else. It should be written with the code as a license, or it should be specified within the contract. What about data protection? Well, data protection is a hot topic, particularly here in Europe and the UK, because we've got GDPR, which I can't remember. Oh, there it is on the screen. That's what it stands for. General Data Protection Regulation, obviously. It's got quite a lot of rules around data protection, but specifically it's data that relates directly to a person, an individual person. So it tends to be any data that can be individually identifiable to a person, like their telephone number or their name or their address where they live. You can identify a person very specifically by that information, and so that must be kept safe and private, only shared with specific reasons, and only kept for a certain period of time. How do we do that? Well, you can have data encryption, so that unless you've got the decryption key, you can't see it at all. And who has access to the decryption key? Well, you have some access controls around that, usually some sort of authentication. And then the privacy policies is around the organization and how they distribute or show or give access to the data, or even delete it afterwards. And then the very sticky question of a data breach response. So if you're an ISO 9000, which is very lots of compliance, it's always a good idea in your privacy policy to have some sort of description to say, in the unfortunate event that we do have a data breach, this is what we're going to do. Now in the UK, it means that you're ICO registered, the Information Commissioner's Office, and you need to report that breach to the Information Office itself. There might be fines involved, so all the better reason to make sure to have that data encrypted and also have those access controls in place. On top of the normal government rules and the GDPR and the legal stuff, you might fall into one of the industries that's also got additional regulatory compliance, like finance and the banks, or healthcare, or of course the government, which covers lots of stuff at a certain level, and then if you're working with the government as a customer, another level beyond that. Stuff like security clearance and things. That can be quite sticky, and those are very specific to those industries, so I'm not going to go too deeply into those. But there is a sort of a general level of compliance that everybody, every business, every person trading has to go through. Stuff like anti-money laundering legislation. Now this is also quite specific around some industries, because unless you're handling other people's money, this won't be a problem for you, other than to make sure your own business isn't accepting dodgy money. Money laundering, for those that don't know, is where some money, usually proceeds of crime, is being put through a process, laundering, as they say, make it clean. Clean means that it looks like legitimate money. And there's, accountants, for instance, one type of profession that has to be very hot on this, because the accountants deal with money all the time, and reporting to the government, and so they're a good conduit to sit in the middle of, here's the criminal gangs that want to make sure that their money looks legitimate, and here's the government reporting, and so the accountants have usually got a good eye on making sure that that doesn't happen. And then there's other stuff. Laws. The only constant is change. Stuff always changes, stuff always gets updated. GDPR wasn't always a thing, and now it is. And so you need to be able to ensure that you keep up to date with the latest regulatory compliance. So let's take a slight little step here and turn our thoughts to liability and indemnification. So as an IT contractor, you could be liable for a bunch of stuff. Now when I say a bunch of stuff, they tend to fall into three categories. The first category is injury to the public. This means that if something you've done has caused an injury to a member of the general public, then you are liable for that or liable for putting it correct is usually the way it is phrased. Now that could be as simple as picking them back up off the floor after they've tripped over your laptop bag, or it could be more serious and you end up with some sort of bill, an unexpected medical bill that they've got to pay, and therefore you're liable for it because without your involvement, it would not have happened. So that's the main one for there is public liability, and so you can have public liability insurance to cover you against that. Then there's employees liability, and that's sort of the same thing. And if you are employing anybody as part of your consultancy, then if they injure themselves, they're no longer treated as public, they're treated as staff and employees, and so they need to be covered. If you don't have any employees, or your employees fall into the exception rules, which is basically family, if they're your brother, your sister, your dad, or your daughter, then they're not in the same rule as staff, apparently. I guess that means you don't have to pay them either. Who knows? And then the third section of liabilities is your customers. So if you've got a customer and they have something bad happen, maybe your code is awesome, apart from in this one situation where it means a whole bunch of people don't get paid, then you might be liable for the fallout that happens in such an event. But nobody died on my watch, so that's good. But to cover you in that situation, there's professional indemnity insurance, so that you can mitigate some of the risk there. And so all of these types of liabilities can be indemnified through insurance, and they all have a limitation of liability. The major exception to that is in the USA. Then there's much higher limits, or sometimes no limits at all if somebody's suing you through the courts. So I specialise in the UK, and therefore I understand the UK best, but I do know that on my professional indemnity, it specifically says does not cover the USA for that very reason, because it's unlimited. So when you do get some insurance, you will be asked, how much insurance do you want? Now, the obvious answer is you can never have too much. But thankfully, usually on an IT contract, the customer will specify how much insurance you should cover. So, briefly mentioned in there, employment. If you are in the fortunate position where you've got enough work on that you need to employ other people to help you, then you need to have some awareness of the employment laws. And so the biggest one that could affect most IT contractors, has to be IR35. And that's where you're classified as a contractor, self-working, self-employed, or whether you are an employee. And if you should be unfortunate to be misclassified, then that can cause an extra liability, usually in the form of tax. So it's important again to have the contract written correctly. Right on the first slide I said, make sure your contract is correct, because the contract specifies what happens in loads of different situations. And if it's been checked by an IR35 expert, then they can make sure at least the contract covers you in the correct way. Likewise, if you do employ employees, sounded odd, then there's the employment contract. Have one written down. Have it so that the employee knows what their rights are. And this is almost as similar to an IT contract, but it will be tailored and specific to human resources law and employees law. So, best practices for compliance. regularly audit and review what policies you have. Whenever you sign a new contract, make sure that it's got all of the major points covered. Whenever you have a new employee, make sure that's covered. When your insurance comes up for renewal, and make sure that that covers what you need it to cover. Are the limits of that insurance high enough and stuff? And all this can then make sure that you've got your up-to-date stuff and it's all reviewed, and hopefully you're covered as best you can. But don't stop there. I mean, it can also have training courses and general awareness of new compliance and existing compliance. As I said earlier, the compliance does change, the rules do change, and then there's case law as well, which can skew quite a lot of the rules as well. This is where the written legislative rules are tested in a court, and that then becomes case law, which can sometimes have a bearing on how the law is interpreted, and sometimes even gets as far as Parliament having to create a new law in order to cover those gaps that maybe they didn't see before. And once you've done all of that, have it documented, so that not only do you know what you do, because I don't know about you, but sometimes I have a short memory, and I was like, did I? Can I remember? But if you've written it down and it's documented, you can refer back to it and you go, right, yes, that's what we decided and that's why we decided it. Perfect. And if it's documented, then somebody else can look at it for you as well. The ultimate documentation is the contract. The next documents after that will be your policies. The next documents after that will be any other supporting evidence that you put together into your company manual that you can refer back to. So keeping a record of the contracts and the communications and the compliance efforts will help. You could go for something really, what's the word? Ironclad, I suppose. There are other compliance frameworks that you could sign up to. A lot of them are probably overkill unless you're an employer of many people, and you all need to have a coordinated effort. At that point, then looking for something like an ISO certification might be worthwhile. But if you're just a 1 or 2 or 3 person company doing the IT contracting, probably a bit overkill. So if you want to know more or want to find out where you stand right now, we've got a quiz that you can fill in. The quiz will ask you a few questions, and that'll give you a report about what you know and what you don't know, and how we can help and how we can work together. And always, if you've got any questions, stick them in the comments below and we'll get back to you. Thanks very much and have a nice day. Ciao.